Hi, I'm Carl Pearson, and this is my video number 130, Parents Can Cancel Student Loan Guarantee or co-note obligor status. And I'm an attorney helping clients end or reduce their debt, and am preparing this video for the parents who have become liable on their children's student loans as co-borrowers or as guarantors of the student loan. I'm a New York attorney and a graduate of Harvard Law School, and I have a most unusual background for student loans. I not only took and fully paid student loans I had taken out when student loans just began under the New York state law before the feds got involved, but for 18 years I was the founder, owner, and president of a for-profit technical school in New York, with most students paying their tuition with federal student loans. I, more than most persons, understand student loans from the standpoint of school and borrower, and am making this video number 130 to tell parents what, if anything, they can do to substantially cancel, or that is to cancel or substantially reduce their liability for student loans they have guaranteed or for which they are co-signers of the student loan notes. I want to say at the outset that no one rule applies to every co-borrowing or guaranteeing parent, which I'll now refer to as the guaranteeing parent or the like. But I want to review what options are generally known and then let you know about a solution available to parent guarantors of about 50% or more of outstanding student loans now in default. I'm guessing at that 50% figure, but it is probably a good figure because my solution applies more to a large dollar liability than it does to small dollar liabilities. And I'm now going to talk about eligible education institutions and qualified education loans. The first thing you should determine is whether the loans in question were made to attend a school where loans do not qualify for elimination in bankruptcy, or were for attending other types of schools, in which case you could eliminate the loan and or the parent guarantee in bankruptcy. Vocational student loans with a private lender for attendance at a school that was not an eligible education institution under 26 United States Code 221D1 and subparagraph 2 means that the loans are not qualified education loans under 11 U.S. Code 523A8 capital B and can be discharged in bankruptcy. If the school closed its doors so that the student did not obtain the course of instruction for which tuition payment was made, a bankruptcy court determined that the loan should be discharged in bankruptcy. Actually, such a determination could also be made by an appropriate state court without any need to file for bankruptcy to obtain release from the loan and loan guarantee obligations of the parent. The Office of Education, interestingly, has a 5-page fill-in form where pages 1 and 2 are for fill-in, called Loan Discharge Application School Closure, OMB number 184-5/0058. Search for Loan Discharge Application School Closure, which doesn't require you to go into bankruptcy or into a state court for relief. You may also be entitled to a refund of amounts you have already paid on the loan. Eligibility for this type of relief is rare, but useful when it applies. Now, as everyone knows, demonstrated long-term inability to pay the loan is a defense which bankruptcy courts have permitted quite sparingly and is not applicable to most students. Parents who probably have more assets and income than their student children would have a more difficult time trying to qualify for this type of discharge of their loan guarantee in bankruptcy. Then there is the Public Service Loan Forgiveness Program for students taking public service type employment, which probably applies to a very limited number of students, and I'm not sure, without doing legal research, how this would affect parent guarantors. But here is the main qualification which few students are able to meet, I believe. and I'm quoting now, "The Public Service Loan Forgiveness PSLF program forgives the remaining balance on your direct loans after you have made 120 qualifying monthly payments, that is, at least 10 years of payment in full-time employment, under a qualifying repayment plan while working full-time for a qualifying employer." For additional information, you can find the government website by searching for Public Service Loan Forgiveness Program, or just put in the initials PSLF and it will come right up to the top in your search. The possible relief described above may be applicable to less than 5% of the student loans now in default, and probably closer to 1 or 2%, meaning that for most students and their guaranteeing parents, there is no relief to be expected from what I have already discussed above. I have a practical solution, which is the reason for this video, and that is that this number one indebtedness problem in the United States of student loans does have a solution, and it may apply to students and their parents concerning 50% or more of the student loans now in default, specifically how parents may be able to get rid of their obligation a different way than what I described above or before. I should mention right away that this should be done only when the circumstances are meritorious, and not if the circumstances I am to describe are not applicable to the student loans in question. Colleges, universities, and for-profit vocational schools are increasing their tuition on average far in excess of any overall inflation rate, and schools seldom reduce their tuition during bad times. Schools are also using a much higher percentage of teaching assistants and part-time instructors to replace the higher cost, more qualified professors, causing a decline in the quality and value of the instruction. Also, as a side comment, schools tend to charge whatever is necessary to use up whatever student loan money is available to students, regardless of the costs of instruction. Tuition charges really have little to do with the costs of instruction, and instead relate more to the cost of regulation of the schools. Without government regulation of education, something which I have unsuccessfully argued in court is a violation of our constitutional First Amendment right to free speech. And if the student lived at home, the cost of tuition could be kept to $2 or $3 per hour of instruction with 20 students in a room. And you'll see later that we're talking about typically $50 an hour for each hour that a student sits in the course, the way tuition is now charged by many colleges and universities. Because of many factors requiring too much time in this video to discuss, schools are offering instruction for corporations and governmental agencies no longer seeking to increase their overall employment in the United States, and are failing to teach skills that would enable graduates to obtain valuable employment with one person or other very small business, professional, and governmental entities in the United States, which could afford to pay $25 to $60 per hour or more to one person with the requisite skills. With the result that graduating students are not being offered jobs with the high incomes needed to pay off these costly student loans and still be able to maintain a minimum standard of living. The job market has changed radically during the past 20 years after development of the computers, internet, and social type marketing programs. And our schools have not kept up with these changes, resulting in lower incomes for graduates of the traditional college programs. A person earning $10 or $20 per hour nets only $8.50 or $15 per hour after taxes, and has little income remaining to pay back $100,000 in loans for 4 years of college, or 8 semesters of 16 weeks each, of 15 hours per week of instruction, or a total of 1,920 hours of instruction over the 4-year period, at a cost per hour in student loans of $52.08. The economics are clear. Colleges, universities, and for-profit schools are often charging far more than a student can pay back on what the school knows is the average income of students who graduate from their program. You can't pay back $52.08 per hour plus interest for 1,920 hours of instruction when you earn only $10 or $20 per hour, because you have to pay taxes and maintain this minimum standard of living, which eats up most, if not all, of your earnings. The schools are not telling students or their parents this sordid fact when entering into the tuition arrangements, and for many students and their parents this amounts to actionable fraud, enabling the students and or their parents to commence an action in the state courts or an adversary proceeding in the bankruptcy courts for fraud to cancel the student loan notes and parent guarantee, or at least substantially reduce them. Remember, however, that what I say does not apply to all students and their parents with student loan problems. Various school programs, especially when moderately priced, provide an education that does enable graduates to obtain employment paying enough to pay off the loans and still earn a minimum standard of living. Without trying to prejudge any specific program or set of circumstances, I would tend to say that nursing courses, automobile repair, law school, dental school, and accounting courses are among those that students or their parents may have more difficulty in trying to establish fraud relating to those programs. I purposely left out medical school because it is conceivable to me that overall student loans could well exceed a doctor's ability to repay when obtaining employment with government-regulated medical institutions, which seem to continually be lowering the doctor's income. A lawsuit in state court for fraud to cancel or substantially reduce outstanding student loan obligations of the parent or the student is the best way for many obligors to get rid of the loan obligation. If you have any questions as to your own situation, please give me a call, no matter where you now live, work, or where you attended school. I see too many students and their parents burdened with student loans that probably could be eliminated or reduced through a meritorious lawsuit in a state court, especially if the loans are virtually worthless because of the inability to repay the loans. There would seem to be little sense for the defendants to do more than make an appropriate settlement of the lawsuit without money changing hands by either canceling or significantly reducing the dollar amount of the unpaid student loans. Consolidation of student loans and forbearance agreements may present more difficulty because of any language which has the students and parents admitting the validity of the debt, but a properly pleaded complaint may be able to anticipate that and cope with that type of defense. Please call me if you have any questions. My telephone number is 212-307-4444. That's 212-307-4444. I look forward to hearing from you.